Sperlin, and I'd like to reserve 5 minutes for rebuttal.
All right, I'll save it for you.
I apologize, they changed clocks and this one's beeping. But
It's all right.
I gotta get it to your 20 minutes. There must be a mute button, but my wife knows what a mute button is, but it's on the back. Found the switch. My colleague found the switch.
There we go.
Lead it to a line and then I'll let him judge. Okay, here we go.
All right, thank you. I'm not going to sugarcoat the facts on this one. This is a really creepy set of facts. I've got a guy who's taking a bank shot off a mirror and winds up taking a fuzzy photo of a girl in a bathtub with her breasts exposed and in a state of elation. But the rest of her is hidden under bath water. And he's ultimately, one of the counts he's ultimately charged and convicted of is video voyeurism. And under the statute, at least the part they charged him under, the state had to prove that she was somehow privately exposing the body, which then you find out exposing the body is actually a term of art. It doesn't mean exposing the body, it means exposing a sexual organ.
But there's no definition of some of the key phrases.
Exactly. There's no definition of exposing, no definition of a sexual organ. So
But it does not say exposure of a sexual organ to another.
In fact, it says privately. And does the fact that the image didn't capture the exposure change our analysis at all? Because isn't the criminal act, unlike the Messner case, the criminal act here is the taking of the picture, not the exposure.
I would suggest the Mester case is a little different because
Agree.
Mester involves the other way that you can do video voyeurism, which is taking photographs of people in their, upskirt, undergarments.
No.
dressing or undressing.
Mesner is the case I think that you relied on.
Oh, Metter. I thought you said Metter. Messner.
Mesner.
Yeah, that was the underwear guy.
Right, and that statute was different. It used the term exhibit, and it's essentially the mirror image here of what we have. For the criminal act, there was the exposure itself. Here,
Right.
the operative act for criminal charge purposes is the taking of the photograph. So does it matter that the exposure was private and that the organ, assuming that breasts are not sexual organs for purposes of this discussion, does it matter that the sexual organ was submerged, and why?
I would assert that the answer is yes, because first of all, for the video voyeurism statute, public exposure doesn't count. So therefore, the word private and exposure have to be mutually exclusive terms. So therefore, you have to expose it and it has to be in private, okay? And the exposure in this case, well, as I said, ultimately we're all naked under our clothes. If we don't watch out, this becomes a really easy prosecution for the state, because.
But she didn't have clothes on.
Well, she was naked.
So she had privately exposed.
She privately exposed.
She privately exposed her entire body because she was fully naked in a bathtub.
Correct, but did she expose a sexual organ? That's the issue.
Would you agree? Could just bear with me for a minute here? Private, we're just deconstructing these words, right? Privately modifies the exposed in this sentence, which contemplates that it wasn't intended for anyone else to see the organ. And the criminal act is the photography of that private exposure. So why does it matter whether the organ is captured in the image? Isn't the criminal act complete when the photograph is taken?
I would argue that, particularly for this part of the video voyeurism statute, okay, that the real thing that the legislature is targeting is the harm of what's happening, okay? And in this particular case, certainly she was exposing the body, particularly from the waist up. Underneath though, hidden by bathwater.
Well, isn't the harm, if we're gonna look at what the legislative purpose was, which gets a little dangerous, especially since it's not expressed here. But isn't the harm the taking of the image when the victim has an expectation of privacy?
Certainly, and that paparazzi photo when somebody's dressed 3 layers head to toe in clothes, that could also be exposing the body too, because we're all naked under our clothes.
None of the statute talks about private exposure of the body. It tells you what the body part is.
It's sexual.
I don't see it getting anywhere with the paparazzi picture with 3 layers of clothes.
Well, I have a question. Did you file a motion to dismiss or a motion to eliminate to flesh all these issues out? Ahead of trial, they just said, let it go to the jury, and then the judges start having to listen to all this, and he tossed some counts out. The jury found guilty on some, and I think not guilty on 1 count. So that the question is, was there a motion to dismiss or a motion to eliminate argued before the trial begins?
I don't believe trial counsel did that in this case. In
Okay.
fact, this actually came up as a supplemental JOA motion when they started arguing about the fact that, well, did she really-
During trial, you mean?
Correct.
No, the only reason I asked that is because a lot of times it's strategy not to file such motion because you don't want to tip off the state. You got an ace in the hole. But if it's ambiguous, you kind of want to get those things out there ahead of time. Just asking, and I know you weren't the trial counsel, and the record's not going to reflect the answer. But so there was nothing filed ahead of time or argued. Okay,
Not that I was aware of.
your turn.
Thank you. Now, to address the points that have been made so far, we have to keep in mind that these statutes have to be strictly construed in favor of the defendant.
Is that so? When there, let's assume for a minute that the statute's not ambiguous. I believe that what our statutory mandate is with regard to the rule of lenity is where the statute's capable of 2 reasonable interpretations. We're required to apply that rule. And so you're assuming that the lack of definition renders the statute ambiguous? Is that, am I understanding your position correctly?
Not necessarily. In fact, I would probably say the fact that we're talking about how you actually expose, whether privately and exposing is mutually inclusive or exclusive, and whether or not merely being naked automatically exposes a sexual organ in the voyeurism. I mean, what if you actually view
Why
somebody
wouldn't it be a
naked for
jury
life?
question? If you don't have definitions, then the jury is entitled to use its common sense. And the jury deliberated pretty good here. You know, they didn't find guilty of everything. Even the judge threw some stuff out. The jury said yes on some, no on another. Generally, it goes to the jury, and once the jury makes a decision, if there's facts to support the jury's decision, we don't get to second guess that.
Well, and that's correct, but ultimately what we had here, it was a JOA, and there has to be at least some competent.
Well, you're saying that was an error. You're saying as a matter of law, he cannot be convicted of any of these charges.
Well, with these strange facts, I would say the answer is yes.
Well, that has to be your argument, or you
Yes.
have no argument. Okay,
Yes,
I got you.
because basically the photograph at best shows breasts and everything else is hidden under bathwater. Even the court had to, even the trial court, when they were
So I
deliberating,
think
had
he
to
was
admit.
trying to take a video of. That's what was he trying to take a video of? He is a pervert. I mean, that's apparently the
Yeah,
jury believes that it's
it's-
not up to anything wholesome.
Yeah, like I
Sneaking
said, it's
around
pretty,
it with the camera.
well, yes, it's a pretty creepy set of facts. I told you that up front.
You did, thank you.
But your focus on the statute, you seem to be taking out the word private and making it a public exposure. The public exposure of the sexual organ would have had to be made publicly to Mr. Spurler. So your theory changes the statutory language.
I would say that in this case, the word privately, okay, it's an adverb. It has to be going towards the verb, which is exposing, okay? Privately exposing what? A sexual organ. Not privately exposing the body, because we already found out body means sexual organ. So the adverb modifier has to modify the verb, which is exposing, as opposed to publicly exposing, like you go out on the street to do it. People can take photographs of that, and that's not video voyeurism. In this case, I don't think anybody's arguing this was private. This was private.
Nobody's arguing that it wasn't private.
Yeah, nobody's arguing that it wasn't private. What we're talking about today is what's really exposing, even if it's in private, what is exposing? Because you have to draw a line somewhere. And because apparently 3 layers of clothing, not exposing enough. Underwear, not exposing enough. Where do we draw the line? And we have.
But if you want to go that far, was the water clear or sudsy?
Well, apparently, according to the trial court, they couldn't see anything under the bathwater. That was one of the issues.
The image didn't capture, the camera didn't capture with clarity
Correct.
whatever was under the bathwater, which we know was the victim's sex organ because she was naked.
Oh, well, obviously she wasn't a eunuch, and therefore we get back to the concept: is the real standard of proof whether or not somebody's a eunuch? You know, if that's the only test, the state's going to have an easy charge with any video voyeurism, because every private event's going to be an exposure, and unless they're a eunuch, easy case.
I mean, it kind of sounds like your remedies with the legislature. You want the legislature to modify the law, or you want us to interpret the law as you believe it should be. And generally, the legislature, if they write a bad statute, they fix it. I have a feeling they're going to say it's fine the way it is, but I mean, that might be your remedy, and it isn't going to help you in this case. But
well, the state has to prove more than just this last piece. The state has to prove that the image was captured for the purpose of degrading or abusing. The state proved that here. The state has to prove that the image was captured at a place and time when the person has a reasonable expectation of privacy. Nobody disputes that this victim didn't have a reasonable expectation of privacy taking a bath in her own bathroom. So the only question is whether she was privately exposing her sex organ. And privately exposing is different to, for example, publicly exhibiting, which was the conduct at issue in Messenger. So I think your real hurdle is the private exposure. The crime here is not what he was able to capture on the image. It was the act of capturing the image when the victim had an expectation of privacy and had exposed herself in private.
And that's certainly a way of looking at it. Of course, we have argued a different way of looking at it, which is arguably another way you can look at the statute, which is why we now have 2 different ways.
Well, even if we get past that whole debate, your backup argument, right, is that her breasts were not a sex organ. And that too involves some interpretation because the term sexual organ isn't defined here. And in other contexts, the legislature has not been so precise as to limit the definition of sex organ to the victim's vagina. They have in other contexts, we have private parts, and the legislature specifically excluded breasts in the exposure statute. If they had meant to exclude breasts from the term sex organ here, they probably could have done that. So I'm just trying to get you to your second point so that you have time on that.
Right. And also likewise, however, in chapter 794, for example, when they're using union with a sexual organ of another, they also include and breasts. Because the legislature recognized in 794, breasts aren't sex organs. So they had to include breast to mouth because, well, people do that with young kids. It's kind of disgusting.
I don't want to interrupt you, but you're coming up to your 5 minutes. Did you want to say 5 minutes for rebuttal?
Yes, I would.
All right,
Thank you.
thank you. Oh, okay. Want to clear this up for us, please?
What's that, Your Honor?
You want to clear this up for us?
Oh, yes, Your Honor. Good morning, Your Honors, and my name is James Hellickson, and I represent the state of Florida, the appellee here. Your Honors, this was a case, and the main issue here was the judgment of acquittal. And so when you look at the judgment of acquittal, you're looking at, do we have facts that are going to go to the jury, or can it be decided as a matter of law? And here, that it was a factual determination for the jury. And I believe the trial court did everything correctly here, because when they initially moved for a judgment of acquittal, it was on intent. And there are.
You admit the facts.
Correct.
Of the state. Well, is there anything inconsistent with the judge throwing out 4, 5, 6, 8 through 12 as at the JOA stage and not these other charges?
Well, Your Honor, those specifically dealt with child pornography. And so I think.
Different charge.
Yes,
Different
and here was the distinction there. So, and it applies a little bit to this, and it is a little bit relevant. So what they did was, as far as the pictures went, they looked at the pictures because there's undisputed evidence in this case that the victim was in the bathtub masturbating with a toothbrush, electric toothbrush. And so what happened was he captures this, and Mr. Sperling knows this is what happens. I believe he tells the detective, you know, I saw her, she was in the bathtub, her boobs were all hanging out, things like that. And they have discussions about what the images actually capture. And so what the trial court did on the child pornography counts is he limited the two where you can actually see her in a state of, for lack of a better term, orgasm. He said these are kind of the pictures that you know.
But that's sort of a red herring, because the victim's state wasn't, that's not part of what the state had to prove.
Correct, Your Honor, but that is why he granted JOA on those other child pornography counts and left the 2 remaining child pornography counts. And those really aren't an issue in this appeal, or on the but that was why those counts 6 through 8, I believe it was, were why they granted judgment of acquittal there.
So can we shift gears and
Yes.
sort of address your opponent's argument? In your briefing, it seemed to me to veer into territory that wasn't really at issue here, which was the constitutionality of the statute itself. I think the real question is, what does this, I don't think there's really a constitutional challenge here. I think is what do these words mean, and did the trial court properly interpret them for purposes of instructing the jury and denying the JOA? So your opponent's position, which has some merit, at least debatable, is the image that was captured doesn't meet the definitions within the statute of what the state was required to prove on private exposure of a sexual organ. Can you address that?
Yes, Your Honor. So you are correct that it's not really unconstitutionally vague, but that was the discussion at the second argument for judgment of acquittal, was that the sexual organ part, you know, wasn't defined and that it wasn't exposed.
So you were preemptively briefing that.
Well, what I wanted to show, Your Honor, was that in order to be unconstitutionally vague, it has to be, you have to have more. And what I wanted to show was that this statute has a standard. It's not completely standardless that you're going to capture, as he was mentioning, you know, you're naked under your clothing. That's not what the purpose of the statute is. It has a very narrow focus. And if you look at it, you know, this child was completely naked under the bathwater. You know, her whole body, as a trial court found, was exposed. You know, it doesn't need to define, you know, a specific sexual organ for purposes of the video voyeurism statute. It does not, because what the video voyeurism statute, if you look at the entire statute, is it's looking to protect victims in certain states of undress. Is the privately exposing the body comes after dressing or undressing. So it's protecting the victim in their private moments when they expect to be having these things that they're not expecting to be photographed or recorded. So if you look at the dressing, undressing, and then privately exposing the body, which means exposing a sexual organ, that's what they're getting at, is that they want the victim's actions to be kept private. And so it does not create.
What's the criminal conduct that is prescribed here?
Yes, Your Honor. So the criminal conduct that's prescribed is that you have to meet several elements. One is an unconsented taking of the photograph. Then you have to have the taking of the photograph with the intent to use it for one of those enumerated purposes, either amusement, gratification, entertainment.
And
that.
let's contrast it for a minute with child exploitation
Sure.
images. Is there a requirement that the image has to capture help me out here.
It-
I think your opponent can meet this on rebuttal. I don't see in the statute a requirement, which I think is different than some of the child exploitation pornography cases, that the image itself has to be pornographic or otherwise capture a private part or sex organ of the victim.
That is correct, Your Honor. And one of the cases that if you look at the first district's decision in Allen v. State, I know the facts are a little bit different. They have a little bit more evidence there because there's some Williamsville evidence in there. But if you look at that case, they don't even have the photograph. And one of the statements that the court makes is, if you look at the gap between when the offense occurred, when he was arrested and when they searched the phone, there was ample time for him to delete the photograph. So in that case, they don't even have the photograph and they still find that the video voyeurism count is permissible. Now they look at some of the Williamsville evidence there, but in that case, they didn't even have the photograph. There was enough testimony to establish by him trying to kind of maneuver the phone, excuse me, Your Honor, under the dressing room door and record her as she's changing, that was sufficient to meet it. So yes, Your Honor, you don't need to necessarily capture the person engaged.
So if I reduce to simple terms, your argument is the image itself is largely irrelevant to the state's burden of proof of the elements for this crime.
So it would matter to some extent because you obviously have to look at, I think that kind of would distinguish between if you're looking at the completed crime versus the kind of an attempt to do it, because I think if you, like in this case, did capture the victim.
He had to have an image.
Right,
But
and
the
he
content
captured
of the
her-
image didn't matter.
Correct. And so like in this case, he captured her, exposed upper body. And that was gonna be enough. It didn't have to show her, as a child porn. It did not have to depict child pornography or an exploitation. It just had
But
to.
your opponent's position on that, and you can address this now, is that since sexual organ isn't defined in this statute, but is defined elsewhere to be limited to that vagina or other parts, not including breasts, that the fact that all that is captured in the image, at least for purposes of being able to see what was going on, is the victim's breast, and according to your opponent, that's not a sexual organ. So can you address that?
Yes, Your Honor. If you look at the way I'm kind of drawing a blank, but that they defined it or that it applies here is that the victim needs to be doing one of those, required things, and then that was what in the picture needs to be taken. So I think in this case that they properly had the discussion about what a sexual organ was when they were discussing the judgment of acquittal, and they discussed, in the sexual battery context, it is limited to penis and vagina. And I think here what the trial court found was that she was completely naked in the bathtub.
So she had privately exposed.
Correct. So even if you could take out the fact that the breasts were exposed, her whole body was ultimately exposed in the bathtub. And I think, in this particular case, you have both, completely exposed. And so I think that they discussed the proper, they had the proper discussion during the judgment of acquittal, and that it was properly sent back to the jury with the understanding that as far as sexual organ went, that the jury could use their common understanding of that term. They didn't have to craft a specific definition of that.
So your position is the statute is not ambiguous. So we don't ever get to principles of construction like the rule of lenity.
Correct. And Your Honor, if Your Honors don't have any other questions, that's really the case was it really came down to the judgment of acquittal. And the state would argue that that was properly denied and the case was properly submitted to the jury. And we just asked the court attorney.
Thank you.
We asked the court attorney to judgment.
That means your time wasn't up.
But I did. I just
You don't have
wanted
to
to
use
make
it all.
one closing comment is that the broader you get under this statute, the less likely the conduct will fall under this statute, because you're likely to fail on one of those elements. Like if you were to say, well, someone's walking down the street and you take a picture, you're probably going to miss the privately that they were in a place where they had a reasonable expectation of privacy. And so I think the broader you get, the less likely this statute is going to apply. And with that, Your Honors, unless Your Honors have any further questions, I just ask you to affirm.
All right. No, thank you, Mr. Ellison. All right, brief rebuttal.
Thank you. The one thing I would offer in rebuttal is that if this is truly an unambiguous statute, then we have to accord these words their plain and ordinary meaning, which exposing normally means bring out to plain and open view.
Except that it's modified here by privately, and the whole, and context is everything.
Sure.
We start here with where the image is going to be captured to make it a criminal act, and it's in a place that the legislature specifically defined where the victim would have a reasonable expectation of privacy, specifically including but not limited to a residential bathroom. So in that context, your argument would make a lot of sense if the legislature also hadn't included the term privately to modify exposing. But I have a hard time in this context accepting your position with the words that the legislature put here.
I understand. I would also posit that there's a reasonable expectation of privacy in automobiles. And there's a surprising number of folks who drive nude, and SunPass takes lots of photos of drivers as they go through toll booths. But they only take the headshots, not below. Is that video voyeurism? Because they're privately exposing their naked.
Do you have a reasonable expectation of privacy in your car? I mean, we're not confronted with that question today,
I
but to
understand.
answer it the way that you would want us to, we'd have to conclude that. And the statute, unlike a residential bathroom, doesn't include an automobile. Probably.
It's an interesting thing. I think the legislature originally started with body, and then because it's weird how they did this to start with. They used the word privately exposing the body, and then all of a sudden they defined exposing the body as exposing a sexual organ. It's almost as if they thought one thing and then all of a
So
sudden.
if we say
decided-
privately exposing a sexual organ, we still have, and that's, I think, a fair read of this subsection D, we still have the privately part. And the context here of don't take pictures of people when they're in a place where they should reasonably be expected not to be photographed, like their bathroom.
I would assert that, yes, this is a place where you have a reasonable expectation of privacy, but at the same token, we've only made certain things in video voyeurism illegal. And I would assert that in this particular case, this is a strange set of facts. Usually we don't have this situation. Usually in video voyeurism, they're exposing their sexual organs. It's plain.
Or you're having an upskirt.
Yeah, or it's upskirt photos of
no.
a department store. It's plain. This is very different because everybody, even the trial court agrees, her lower part of her body is obscured by the bathwater, and it's a really fuzzy photo. Thank you.
Very good, thank you. Concludes that case. We'll move on to the next case, which is Karen